everybody. I think we're going to get started. So we've got another great panels here now. We're going to be talking about state, local, and tribal government. And we have Professor Villazor from UC Davis, Professor Ming Chen from Colorado, Martin James Diamond, professor and also in our clinical program at the U of A, and Professor Peter Spiro from Temple. So turning the panel over to them.
Good afternoon, everyone, and I just want to extend a warm appreciation and thank you to Professor Andrew Cohen and the University of Arizona for inviting me to be here today. As you can see, the panel, my talk for today is entitled Sanctuary Campuses and Immigration Federalism. It flows naturally, I think, from the panel, the earlier panel that had a robust discussion about sanctuary cities. This panel, of course, is entitled State, Local, and Tribal Government Issues, and the idea was to explore federalism questions from their perspective. Mine takes up the federalism question from the sanctuary campus perspective and where it fits in within the state and federal discussions about a number of legal issues that I'll soon talk about. Almost 10 years ago now, I wrote a law review article that is entitled, What is a Sanctuary? And I wrote it in 2008 to respond to what I saw was a large confusion about what the term sanctuary meant. Even today, we still don't have consensus precisely on what it means. But from my perspective at the time, I saw that a number of cities began declaring themselves as sanctuary cities, or that they issued policies that said that they will not cooperate with the federal government. Similarly, there were also churches that began to declare themselves sanctuary. That was not new. Sanctuary cities began in the 1980s in response to a refugee crisis that was going on in Central and South America. And so many cities in the 1980s declared themselves as a safe haven, as a place that would be inclusive of refugees. Also, the churches respond in the mid-2000s to offering undocumented immigrants a sanctuary, a safe haven, was not new as well. Also in the 1980s, there were a number of churches and religious ministers and other groups who responded as a way to offer a humanitarian response to the refugee crisis that was going on at that time. Sanctuary cities, as I argued in that article, raise a number of distinct questions from churches and individuals. And in particular, for purposes of our panel today, I raise in that article, as many others have done who write about sanctuary cities, that the big federalism question that is raised is whether there's a violation of 8 U.S.C. 1373, which is known as the communication between government agencies and DHS. And that particular provision imposes may be viewed as imposing some restriction on the ability of federal, state, and local governments to share information or not share information with federal immigration officers. So if there are any kind of sanctuary city policies or non-cooperation policies that may restrict in some way the sharing of information with the federal government, then the legal question becomes whether there is a violation of 8 U.S.C. 1373 that says that these officials may not be prohibited from sharing such information. That federalism question is distinct from anti-harboring, or the legal question that typically faces churches and individuals who choose to provide a sanctuary for individuals. And there, one of the key legal questions is this long statutory provision is known as the bringing in and harboring certain aliens. There, the issue is whether the churches or individuals providing a safe haven within their homes or within the church are harboring that is preventing undocumented immigrants from being detected by immigration officers. In that piece, I highlighted that the mere provision of housing is not harboring. That's where the case law is right now. One has to do more than provide a mere sheltering in order to be found guilty of violating this criminal provision of federal law. Similarly, with respect to sanctuary cities, I also argued then that sanctuary cities, because we don't have a clear definition of it, should not be so broad as to include cities that pass certain laws and policies that are completely within their power, within their control. So, for example, a city that provides a municipal ID, it would not be right to call them a sanctuary city because that particular issuance of a municipal ID is solely within local government law. Okay, so this was in the mid-2000s, and I said this was sanctuary cities and churches and individuals. They were giving safe havens earlier in the 1980s. It seems, as we've seen historically, that whenever there is a heightened enforcement of immigration law, then we've seen cities and individuals asserting some policy in order to provide more protection for undocumented immigrants. What we began seeing as of late, since 2000, is the rise of sanctuary campuses. This is a new movement that we've seen across the United States. Here is a picture of the different places where individuals, students, faculty, advocates have been pushing their universities to issue a sanctuary policy or some form of a policy that is designed to provide some protection for their undocumented students and some for their families. What exactly are these sanctuary policies that we've seen? There is also no consensus, but here are the 3 points that we've seen through by just based on the statements that the presidents or chancellors of many of different universities have passed. So the key one that we've seen across the board is no sharing of a student's immigration information with federal officials, unless there is a judicial warrant or a subpoena, right? And so that is, of course, critical for many of the students who were afraid of their information being shared, particularly for the DACA students, the students who were given the ability to, because of a lawful presence under the discretion issued by the President Obama's administration. These DACA students were afraid that somehow, under the new administration, their information might be shared by their universities. So sanctuary campuses have said no sharing of student information. Many campuses have also said providing support for DACA students. Some have done it through providing financial support. Others have done it through providing legal services for any kind of issues that they might be facing. And then other campuses have actually extended their policies beyond what many others have said. Schools such as Columbia University, for example, said no ICE on campus unless there's a warrant or an arrest. Okay, so we've seen these 3 different policies highlight something new, right? Where do sanctuary campuses fit in within our understanding of the debate within federalism? When a sanctuary city is accused of violating 1373, the legal issues that are raised there are whether the federal government can commandeer a state city or a state or a city to enforce immigration law because of 8 U.S.C. 1373. Sanctuary campuses raise distinct but related questions. Public universities might be, the argument goes, might be subject to the same limitations that have been imposed on public employees who are working for sanctuary cities. But not all universities, obviously, are public, right? There are private universities, and their concerns might be whether the providing a house or a shelter through dorms or apartments, may they be subject to the anti-harboring provision of the federal law. You're familiar with your former governor, who is our president of the UC system. She has issued what we've seen in the University of California, a wide support for DACA students and their families in preventing ICE from coming to campus, providing DACA students with legal services to help them figure out how they might be able to adjust to a different status. And so there are a number of legal issues that are raised by sanctuary campuses that are distinct from what we've seen in the public setting, the sanctuary cities, and as well as the private setting. At least 3 questions are being explored. I'm exploring 3 different questions with my co-author, Deep Gullisakaram at Santa Clara Law School. First is what is actually meant by sanctuary campus. As I've noted, it's unclear right now precisely what that looks like. We've seen a number of different policies, but where might they fit in within the overall construction of what is a sanctuary? And then I've written in the past about immigration and property intersection. And so to what extent can a private university use its power to exclude ICE? And to what extent can a public university similarly do the same thing? Public universities are, of course, by its term, supposed to be open to the public. But universities, whether public or private, are distinct. Right? Their overall goal or mission is to educate students, which under case law has also included providing protection and for their students, including protecting their privacy, the privacy of their information. Then a related issue that we're exploring is whether this particular question about concealing and harboring or shielding from detection undocumented students, and whether there's a violation of this law when a university, public or private, are providing housing to undocumented students. Putting those issues aside, there are a number of questions that we can think about from a federalism standpoint. And here, with the time that I have left, I'd like to talk about 2 bills that have been introduced, one at the federal level and then one at the state level. Under No Funding for Sanctuary Campus Act that was introduced in January of this year, Congress, the sponsors of the bill says that it is the sense of Congress that the provision of in-state tuition creates an incentive for illegal immigration. So it's interesting that this is the sense of Congress, because we're talking here about the purpose, according to this bill, the purpose here is to disincentivize illegal immigration here to the United States by stopping in-state tuition. In-state tuition is something within, as states would argue, within state control, right? And yet Congress is trying to use that as a basis of federal law violation. According to this bill, sanctuary campus is quite broad. Here it says it of course addresses ordinances or policies that would prohibit any institutional entity from sharing, exchanging information, sharing or receiving information with federal officers, the federal government. So that addresses these policies that I mentioned earlier. But then also it expands the harboring provision to include this, to say that if a university is harboring an undocumented student, then they would lose their funding. And ultimately, this bill will deny funding for universities if they don't share information, if they, quote, harbor undocumented students, if they provide an educational benefit based on residence. So that is, if an undocumented student gets in-state tuition as a result of residency in that state, and that would constitute a violation of this bill, which could become law, because that school is supposedly a sanctuary campus. And then finally, if a university bans ICE from campus, that makes that university a sanctuary campus, and so therefore would be defunded. Alabama has passed something very similar as well. Passed a bill. So the first one, this one, HR 483, has been introduced, whereas Alabama passed a sanctuary bill last week. And it's a similar idea, defunding a school for creating or passing some type of a sanctuary policy. And it allows the Attorney General to pull state funds from colleges and universities. So that's interesting. We've got 2 different entities here, the federal government as well as the state government, trying to control, using the power of the purse to restrict the ability of universities who are on their own with their own mission, trying to address the clear needs of their students. So three issues that these particular bills raise are these. One is the idea here that educators and administrators ultimately become de facto immigration officers, right? For public universities, should they be subject to the same kind of limitation that are imposed on state and local government officers? And then if for those educators and administrators who work for private universities, should they in essence be conscripted to enforce immigration law? These bills also conflict with the law, what's called FERPA, Family Educational Rights and Privacy Act, which already protects students' information from being disclosed unless there's a warrant or a subpoena. And finally, housing concerns. Of course, that's critical for students. Where will they reside if by residing their very mere presence on campus would constitute a violation, would subject their school from losing their funds? These are three different issues that it would be helpful for many of us to consider as we determine exactly what might be the proper scope of federal restriction on what people can do in response to heightened deportation and anti-immigrant policies today. Just want to close the talk with a quote from Dr. Martin Luther King that brings us back to the purpose of universities, right? He said, "The function of education is to teach one to think intensively and to think critically. Intelligence plus character, that is the goal of true education." This particular mission of universities are at stake at this point, are subject now to these different bills that have been passed on the bill that's passed on the state level, that other states might follow suit, but also on the federal level as well. Thank you.
Thank you all for staying into the afternoon, and thank you especially to the University of Arizona, to the Rehnquist Center, to Andrew Cohen for having me here today as part of this really timely, really important conversation. Like my panelists, I wanted to present a different case study of local involvement in federal immigration policy. And I wanted to do that by situating the particular phenomenon of refugee resettlement within the frame of cooperative federalism. In the big questions that I think about in this field of cooperative federalism as a whole are the relationship between the federal government and states in the formation of a national immigration policy. So not necessarily a federal immigration policy, but a national immigration policy that includes both state and federal actors. And when I talk about that relationship, I am thinking both about the formal boundaries between those two government entities, in terms of some of the themes we saw this morning, in terms of preemption, anti-commandeering, those kinds of questions. But I'm especially thinking about, and for today's presentation will especially emphasize, just characterizing the nature of those relationships in ways that go beyond the formal boundaries between those governments as sovereign entities. Now, for those big themes that I just laid out, I could have used 5 or 6 different examples that have arisen in the last 2 months. Certainly I think these themes, and I hope that the takeaways from the case study are ones that can help you think not only about refugee resettlement, but I thought by this point in the day, for sure, someone would have already talked about the travel ban or the Muslim ban, whatever you may prefer to call it. But in particular, with the recent lawsuit on Washington versus Trump, and parallel lawsuits coming out of California and Hawaii, the way that the state standing argument has been made that refers in part to the harm to universities, and specifically public universities. Certainly the sanctuary city provisions from the executive order that my colleague Rose Villazor just referred to, that also raises very, very similar issues. All of the law enforcement examples we just heard about in the panel before lunch, with 287Gs, immigration detainers, the return to secure communities, all of those raise those issues too. So I was just making a bet that maybe no one had talked about this case study yet. So it's the one I decided to go into, and it's a new one for me. So if there are people out there who know a lot about refugee resettlement, please inform me and help me improve my thinking on this one. So first I just wanted to go back to the executive order. This was the 3rd executive order that President Trump signed into effect this year. And this is one particular provision within it that I think has not received very much attention. So to remind you, the full title of the executive order is Protecting the Nation from Foreign Terrorist Entry to the United States. Most of the attention has focused on Section 3, which is the provision that bans travelers coming from 7 specified countries within the executive order. Section 5 is the provision that concerns refugee resettlement. And among other things, Section 5C concerns the suspension of the U.S. refugee admissions program. Section 5D caps the overall number of refugees to the United States at 50,000 per year. And Section 5G, which is the one I want to focus on today, says that it's the policy of the executive branch that to the extent permitted by law and as practical, state and local jurisdictions should be granted a role in the process of determining the placement or settlement in their jurisdictions of aliens eligible to be admitted to the United States as refugees. All right, there's some additional language on the slide. The question that I think this provision raises most fundamentally, though, is what does it mean for the state and local government to have a role in refugee resettlement? Well, as things currently stand, the Refugee Act of 1980 does give state governments a role. The federal government is required to consult regularly with state and local jurisdictions concerning the distribution of refugees. In practice, refugee resettlement occurs with very limited input by states under that provision. So I think there is a potential with this provision, which is new, by the way. This is something new and untested. So it is hard to know exactly how this would be interpreted or implemented, and I suppose for that matter, as I understand, the executive order is being revised and rewritten right now, so presuming that the provision remains in the executive order, I haven't heard any speculation that it would be removed. What Section 5G could do could be significant even if that role is not actually a legal veto, which I think would be difficult under the current parameters of the Refugee Act. What I mean by the role in understanding how the program works is that states could cut their own funding and essentially opt out of the refugee resettlement program. I'll say a little bit more about that. But as with many cooperative federalism regimes, there is an element of voluntariness here. And so one option for states is to simply not participate once they are empowered by having this role affirmatively ascribed to them in the executive order. Another thing that states can do is to make the process more cumbersome, either for the federal government or for VOLAs, voluntary agencies, that end up being involved in the distribution and provision of services to refugees within the state. I also want to highlight that it is, of course, possible that states and localities could accept more refugees. That could be a different way of construing that role. So let me give you a little bit more background, and again, this will be just a thumbnail sketch of how the refugee resettlement involves the state and federal government. States do receive federal funding from the Office of Refugee Resettlement, and that serves primarily for purposes of cash and medical assistance, social services, targeted assistance, and preventative health. Now, as it stands, states can choose one of 3 models for disseminating those funds for the purpose of refugee resettlement. They can operate state-run offices, so acting directly as an administrator or in the implementation of those federal funds. That's true for 32 of the 50 states we have right now. They could instead choose a middle ground of a nonprofit voluntary organization hybrid. So that is a partnership between public and private organizations within the state. Or they could choose a Wilson-Fish alternative, which also involves cooperation between the state government, which primarily brings the nonprofit organization into the role of performing functions that could otherwise be performed by the state-run offices. And that the Wilson-Fish alternative currently is about 12 of our 50 states, and the nonprofit voluntary agency partnership is about 5 of the 50 states. So point 1, when I say that states could involve themselves, they could create the role by cutting themselves out of the process. That would essentially be the move toward one of these models that is more dependent on nonprofit organizations, getting the state itself largely out of the business of refugee resettlement. I should point out that for all the numbers, I don't know if anyone was counting, but 32 plus 12 plus 5 doesn't actually get you to 50. Wyoming is one state that chooses not to participate at all, and doesn't also have a nonprofit that stands in its place. So that would also be an example of opting out of the refugee resettlement regime. So another option, as I said, would be for the states to make the process more cumbersome by, in a variety of ways, simply not cooperating with the federal government, again, even falling short of an actual veto of the federal government's decision to relocate refugees within the state. And in past writing, I've talked about this idea of cooperation and non-cooperation running along a spectrum. I don't think of this as a binary where, again, the state can vote up or down on the decision of the federal government. Instead, they might vote to encumber the process in a variety of ways. And for the sake of time, I won't go through all of this legislation, but I would point out that there have been a number of state actions that originally came into play under President Obama's administration, when in response to the Syrian refugee crisis, he had agreed to increase the overall cap for refugees. And a number of states had made various forms of statements of opposition, had passed legislation, had passed executive orders at the state level, or had directly challenged the implementation of the refugee resettlement plan within their states. Probably among the more notable would be the executive order in Indiana that was issued under then Governor Mike Pence, who's now our vice president, and is rumored to have had a role in the drafting of Section 5G in the current executive order. The lawsuit that was filed against his executive order that itself would have aimed to persuade the voluntary organizations within his state to not resettle refugees, and also to block some of the federal money from going to those nonprofits. That lawsuit was joined by 31 governors before it was ultimately struck down in the Seventh Circuit on the basis of equal protection grounds, that it might be discriminatory on the basis of national origin. Another example that's illustrative of the various forms of opposition or non-cooperation to President Obama's pledge to increase refugee resettlements would follow in the model of the state of Texas, which is one of the 32 state-run refugee programs, and the one that receives the highest number of refugees. So for Texas to take a stand to say that they want to withdraw from this program certainly received a lot of publicity and notoriety because it is such a big player in this particular area of refugee resettlement. And the idea, and I suppose the concern would be that for Texas to withdraw, you might then see a cascading effect, right, where other states might begin to withdraw as well. And indeed, Kansas and New Jersey, just in the last year, have also withdrawn from what was originally their state-dominated model. To round out the picture, as I mentioned, another response that is possible from states as well as localities, of course, would be to increase support for refugee resettlement. And the federal government would certainly provide cash as incentives for that kind of response. There have been states, including the state of Colorado, where I'm here from, that have made affirmative statements of welcome to refugees since Obama's executive order and renewed support since the Trump administration's issuance of Section 5G within the executive order. Primarily, though, what you see is that while states have stepped forward, 30-some states, to oppose refugee resettlement, what you've seen is mayors of cities that have been stepping forward to issue the statements of welcome. And so, I don't know if you can read the dots, but what's of more interest perhaps than the coloring of the states is the isolation of particular cities that have taken that stance. There was in particular a letter from 18 different mayors that included this language, that we will welcome the Syrian refugee families to make homes and new lives in our cities. As well, the state of Michigan is another that has stepped forward at the state level to be part of this Welcoming America movement. So again, this I think illustrates the third of the possible responses for a cooperative federalism regime, which could work unexpectedly in a manner to link together the Trump administration's executive order on a role, defining a role, with the prior decisions in the executive branch about refugee resettlement. So let me conclude with just a few thoughts on bringing this back to the general picture of what we can learn for immigration federalism, and in particular, what we can learn for the cooperative federalism strand of this larger debate. I think one important issue to realize is that federal immigration policy relies on partnerships. And again, I use that language of a national immigration policy. But even at the federal level, where refugee resettlement might be one of the first examples to come to mind, as one that is typically dominated by the federal government, that it still can't act on its own. That in many ways, the federal government relies on states to act as an administrator of their program, and that nonprofits also have a role in this. I know this is, again, something that Professor Villazor has written about, but when we talk about the state and the federal government, we are also needing to carve out space for the nonprofit and private actors, such as churches, that might also be in this business as well. The second big point that I'd want to make is that cooperation and non-cooperation are on a spectrum. And again, that I think it's fruitful to push beyond the binary that is implied by the doctrinal frameworks that we have of preemption and anti-commandeering. And that I think it can be constructive to dig deep into the specific policy examples we have to build typologies of what, again, that state role could look like. Certainly within the range of resistance or dissent, trying to understand what the different types of relationships might look like, but also allowing a space for support. And so I think about Hirschman's iconic statement that one way you can respond is exit, voice, or loyalty. That might be one way to think about the roles that states and localities can play. Exit through the opt-out. Voice, I think, is the one that's particularly interesting. There have been constitutional law scholars like Jessica Goldman-Posman in particular, who has talked about the idea of licensed dissent, which I think could be an interesting way to think about Section 5G, where there is a written provision that permits a state to dissent from the federal role in refugee resettlement. And lastly, that states, cities, and nonprofits can act not only as implementers, but also as policymakers in their role in federal immigration. And Section 5G, I don't remember if I put the title on it, but it was titled as Realigning the Refugee Resettlement Process. And so that idea of realignment, to me, in some ways sounds like more than a response, but potentially a generative role that the state could play.
Good afternoon. I've been asked to speak about how Indian law and the recent proposed border wall across the border affects one particular Indian tribe here in southern Arizona. And so I'm going to start with just an overview of federal Indian law. And for those of you who understand it, know it, it's a review. For those of you who haven't been exposed to it, it's new. So Indian law in the United States is a complex maze, depending on what the subject is, where a particular conflict arises, the nature of the land that's affected, and the particular indigenous peoples affected. The State Attorney General of Washington, and not the one recently in the news, once said, one reason the state of Washington and its Indian citizens have frequently been in court is because no one truly understands exactly what the position an Indian tribe occupies within the federal system. And LaDonna Harris, a Comanche activist, said, we're part of the federal system, not part of the states. Our political relationship is not well known, little understood, which causes a great deal of problems, which is true. So, obviously, the Europeans arrived in North America, and the continent was already occupied. And then, comprehensive colonization occurred at the end of the 15th century. It continued first peacefully, and then militarily. Britain and other foreign nations, nation states, and then the colonial government here in the U.S. Negotiated treaties with the Indians. And treaties, we know, are negotiated between sovereigns, a clear indication that the status of the Indians at that time was as most closely related to a sovereign power, independent sovereign powers. The treaties were intended to negotiate peace, end warfare, regulate trade, ended up with the Indians giving up land, often with a reservation of rights like hunting and fishing rights within established borders. All of these concepts were very strange to the indigenous peoples, and most likely the treaties were not necessarily understood by them as the Europeans understood them. So our new federal government clearly evidenced their belief of the Indians as sovereigns in the Constitution themselves, in the Commerce Clause, where they placed the relationship between Indian tribes, and in the language where they referred to the power of the government and Congress's power was to regulate commerce with foreign nations, among the several states, and with the Indian tribes, showing a resemblance closer to a foreign sovereign than anything else. And early Supreme Court cases also treated the Indians as sovereigns. Cherokee Nation versus Georgia, where Chief Justice Marshall said, the acts of our government plainly recognize the Cherokee Nation as a state, and the courts are bound by those acts. Well, the treatment of the early treatment of the Indians as sovereigns, and in the forms of the treaties and the Constitution itself, had a profound impact on the Indians and their psyche, and it's an impact that has continued to be felt today. It's a sentiment that continues to be felt to this day. So the Constitution gave power to Congress, plenary power, to regulate Indian affairs, but also quickly established the role of the federal government to protect Indians from state governments. Chief Justice Marshall invented a new term for them then in subsequent years, calling them, quote-unquote, domestic dependent nations. And very quickly, almost immediately, the courts, the executive, and Congress found it to be inconvenient to their expansionist desires to have sovereign nations in their midst, and they began to limit the power of the Indian nations. Over U.S. history, Congress retained plenary power over the Indians, often delegated to the executive branch with very limited role of state governments, with a few notable exceptions where there is a preemption, like in the area of gaming, for example. And that congressional plenary power continues to this day. And to this day, as extra-constitutional political bodies, Indian tribes are not subject to the constraints upon the federal government in the Bill of Rights, and they maintain broad, largely unreviewable powers over internal tribal matters. They further possess to this day common law immunity from suit by parties other than the federal government, absent a waiver by the tribe or congressional statute. Which brings us to one American Indian tribe and a proposed wall across traditional lands. In the 16th and 17th centuries, there were thousands of Otham people in the Southwest. They weren't completely uniform. They had differences. There were several bands of people who were related in spiritual belief, family, clanship, culture, and language. They were an agricultural people and remain so today. After the war between Mexico and the United States in 1854, the nation signed a treaty. The Treaty of Guadalupe Hidalgo, it's known to many of you, negotiated the Gadsden Purchase, and the combined result was the annexation of much territory in the Southwest of California from Mexico. And this, of course, established the border that we've been talking about all day. However, the border divided the Otham people. You can see on the slide, on the left, the traditional Otham land. The border very unnaturally went right through their lands. In 1874, a reservation was created by President Grant, by executive order, I should indicate, later enacted into law by Congress. The reservation was expanded over the years by later executive orders and acts of Congress to over 2 million acres. The reservation, there's a map on the right of the reservation today. It's, like I said, over 2 million acres, a vast expanse of land, of mountains and valleys with a long and harsh summer. And the border itself is a completely unnatural division. In fact, the border to this day divides the Otham. There are 9 Otham communities on the Mexican side, with approximately 1,500 enrolled Otham members in Mexico, about 30,000 members, enrolled members on the U.S. side. So I appeared at a panel just last Friday, at the capital of the Otham Nation in Cells, and I listened to their concerns about the border wall and how it will affect them. And whereas I can't speak for them, wouldn't pretend to, I listened. And so I can tell you what I heard. The problem on the nation is severe, a law enforcement problem, and they have talked about the problem, mostly drug smuggling across their nation, coming from the cartels, Sinaloa and Tijuana Mexican drug cartels. They have a tribal police force, and the police force, their activities are dominated by investigation of drug smuggling, drug seizures, some human smuggling, investigation into dead bodies found on the nation, border-related violence, stolen cars, etc. And in the past, they have requested assistance and cooperation from the federal government, and they have cooperated in turn with their efforts at law enforcement. But what has occurred is a militarization of their land, and that has concerned them drastically. Many of the members of the Otham have family members on both sides of the border. They cross the border regularly to see family. They cross for religious pilgrimages, notably what they call their Salt Pilgrimage and the annual St. Francis Pilgrimage to Magdalena, Mexico. They cross the border for cultural celebrations, to visit sacred sites, for economic and agricultural reasons, to buy and sell goods. They complain about increased border controls, making it difficult for Otham on both sides to cross. They complain about Otham members who are U.S. citizens on the U.S. side being stopped and searched by federal law enforcement without any legal justification, because as we've talked about today, searches at the border are an exception to the search warrant requirement under the Fourth Amendment. Routine, what's referred to as routine searches, don't require any suspicion at all. Non-routine searches typically require a reasonable suspicion and not probable cause that a crime has been committed or the person is carrying unlawful contraband. And this results in Otham members, citizens, being routinely stopped and searched near the border, not necessarily when they're crossing the border. The Otham believe that a wall will harm their ecosystem, will interrupt the flow of water back and forth across their land, will keep animals from migrating back and forth. That there are some 30 endangered or threatened animal species at the border region. And the land and the animals are very, very important to the Otham people. They say that the wall will cross sacred sites and burial grounds on both sides. And they refer to the wall, the land is absolutely stunning. They refer to the wall at this meeting as a scar upon our traditional lands. The Otham say they have patrolled and protected their own lands for hundreds of years, first from Spanish invaders and then others, that they know their land the best, that they know their people the best, and that one possible solution for them is to ask for resources to patrol their own land. Of course, an argument against that is that they themselves haven't been successful in recent years at doing that, but then again, neither has the U.S. government. So the Otham say that after years of cooperation with increased militarization of their land, cooperation which began with the construction of border fencing under President Bush and President Obama, their cooperation, really the latest proposal to build a 20-foot high, either concrete or steel wall, really for them is the last straw. And so the Otham, oh, that's not a page I'm going to need. The Otham recently, 2 weeks ago, passed a very strongly worded resolution to oppose the wall. And it's in particular, a very strongly worded resolution which is historic for them. And they did so just 2 weeks ago. So what legal grounds do the Otham have to oppose this wall? Well, first let's talk about international law. International law obviously gives the U.S., a sovereign nation-state, broad powers to enforce border controls, a power the Otham, as a limited sovereign, don't have. There are, however, protections in international human rights law for indigenous peoples whose lands are on international borders. And in fact, Article 36 of the Declaration of the Rights of Indigenous Peoples says, indigenous people, in particular those divided by international borders, like the Otham, have the right to maintain and develop contacts, relations, and cooperation, including activities for spiritual, cultural, political, economic, and social purposes with their members, as well as other peoples across borders, and nation-states have an obligation to work toward reaching that goal. There's another article in the Declaration which says that military activities, which you have to consider what we are talking about proposing here, shall not take place on the lands of indigenous peoples unless justified by a relevant public interest or requested by indigenous peoples. And in fact, it has been requested in the past. An obvious problem with enforcing this human right document is there is an obvious public interest. There are various other international human rights documents and enforcement bodies that give indigenous peoples rights to enjoy cultural and religious practices. So the UN has processes for lodging complaints of human rights violations, like filing a petition with the Inter-American Commission on Human Rights, or the UN Human Rights Council, and our law school, our College of Law, has in fact participated in many of these, sometimes with success, sometimes unsuccessfully. The hearings are conducted, and nation-states are asked to defend and justify their actions as they affect indigenous peoples, as would a border wall. But a number of challenges are presented by this potential solution. First, the process is very lengthy. It takes years to get a petition approved and then get a hearing. And second, while the U.S. might be embarrassed, indeed, by finding that they violated human rights documents, the ruling is not binding. Another major obstacle on relying on international human rights law is that the Otham either have to show and find that they have exhausted domestic remedies, legal remedies here, or that domestic remedies are unavailable or unnecessarily delayed, which brings us to domestic remedies. First Amendment, free exercise clause. So the Otham could pursue a challenge on the basis of their rights to free exercise. Those have been, Indians have had a hard time under both Ling and cases like Navajo Nation, where they have to show a substantial burden. Environmental statutes are another possible remedy, but with the waiver provisions, those are unlikely to be successful. Just in closing, the Otham are likely to pursue all of these remedies, and their symbol for themselves is the man in the maze, the navigating the rigors of life. And one thing is clear: they've survived Spanish efforts at colonization, assimilation through the gentle pressures of Jesuit missionaries, manifest destiny, etc. They're survivors and likely to survive this latest barrier, literally, to the retention of their unique worldview and their view of the world.
So I'm going to add a little diversity to this panel by not having a PowerPoint. And I'm also not going to give you a case study. In some ways, what I'm going to talk about goes back to the first panel this morning. And if I were to give a title to my talk, it would be to play off of David Rubenstein's leadoff talk, and modify it to we can't have, or you can't have your cake and eat it too, and why that might not be as bad as one might think. And the premise I'm going to work with here is that whichever view you have on federal exclusivity, it's difficult to engineer it in a way that stops sub-federal jurisdictions from doing the bad and allows them to do the good, whatever your definition of bad and good may be. So this cuts both ways, and although Hiroshi Motomura does an admirable job of trying to shift the scales by injecting equal protection doctrine into the mix as sort of a backstop in protecting against restrictionist activity at the sub-federal level, I'm not sure we can count on that at best. At least it's interesting, but untested. And so what I'm going to do here is posit a world in which there's little judicial interference with state and local modulation in immigration enforcement. And what that means in terms of where we may end up is that we'll have a very high regional variance in enforcement, and much more than we've seen in the past. So that on the one hand, we'll have sanctuary cities, or maybe more appropriately called sanctuary zones. So we could include, for instance, Rose's sanctuary campuses and some non-state, other non-state actors who are protective of immigrants regardless of their status. So sanctuary zones on the one hand, and then something on the other hand, which actually doesn't really have a name yet, and I was playing around today with different possibilities of low tolerance zones or high enforcement zones, places in which the enforcement is going to be ramped up. And so I want to just take a couple of minutes to look at how we get there and what this increased regional variance looks like, and then briefly talk about the sort of not as bad as one might think bottom line here in terms of playing out competitive federalism in this context, that there may be a dynamic in which even without the intervention of the courts, a dynamic of this variance at the sub-federal level may actually work to advance immigrant interests. So at the top, though, I have to say that this is necessarily provisional. These are sort of necessarily provisional observations in the new world that we're living in. I've been sort of impressed by the course of the discussion today at how rational it all seems, which is definitely not the world that I'm seeing on my Twitter feed. So with some hope that we can address this in a rational way, but who knows sort of what's going to happen tomorrow with all this, and whether trying to unpack this in some sort of rational way actually ends up reflecting what happens on the ground. So with respect to sanctuary cities or sanctuary zones, a lot of the attention is focused on detainer policies. I think because because that obviously has been a flashpoint, a pre-existing flashpoint we had in the Obama administration. Continuing now, it's very doctrinally rich. There are a lot of moving parts in terms of the doctrine here, not just with respect to preemption doctrines, but you also have the injection of other constitutional doctrines relating to federalism that play to the advantage of protecting sub-federal action in the context of the detainer questions. But if we're looking at characterizing these sanctuary zones more broadly, obviously it goes beyond these questions of detainer policies. And we've heard at various times today mention of things like municipal IDs, in-state tuition, state diversionary policies that Dan Canstrom was talking about. One thing that I hadn't seen mentioned lately, but which was being floated during the Obama administration, was states, New York State in particular introduced the idea of state citizenship, decoupled from national citizenship and from immigration status, so that it would have been possible under a bill introduced in New York to have New York State citizenship even as an undocumented immigrant, which is an interesting possibility, and points to, I think, and Dan here spoke about sanctuary cities at a rhetorical level, and I think that's really the important element here, is that there's a sense in these zones of counting immigrants as members of the community regardless of their immigration status. And that's been reflected in this, the resistance that we've seen in recent weeks to various Trump administration policies. And so it's really a culture of welcome, of protection, and there are questions with respect to the enforcement intensity within these sanctuary zones, what the Trump administration is going to do. I think part of that is contingent on whether this intense resistance can be sustained, and whether the Trump administration will be politically responsive to this activity. In one respect, it makes no sense for the Trump administration to be aggressively enforcing immigration laws within these immigrant-friendly jurisdictions, right? If in Philadelphia, New York, Chicago, Los Angeles, if the people of those jurisdictions want to have immigrants regardless of their immigration status, what does Donald Trump gain by invading them? Obviously he thinks he's gaining, or it looks like he thinks he's gaining something, notwithstanding the fact that that we have confrontational situations resulting in maybe, one thing that makes it difficult to rationally analyze what's going on now is that the Trump Bannon administration may be interested in creating chaos and disruption. But so there are questions about to what extent enforcement can be resisted in these immigrant-friendly jurisdictions. But even if, for instance, on sanctuary campuses, the universities can't actually keep ICE out, they'll still be perceived to be more friendly than those jurisdictions on the opposite end of the spectrum, these lower tolerance zones, where I think there's a very good possibility that enforcement will be ramped up now during the Trump administration. And the features of these low tolerance zones might be, again, can't isolate one characteristic of these zones, but it's a combination of ICE being quote unquote unshackled, which is a sort of unfortunate use of the word with respect to ICE, and might go a little bit to Joe Landau's point about kind of administrative federalism, where at the level of the field offices, you'll have ICE more aggressively pursuing enforcement in contexts in which ICE may feel like it's work is more appreciated. Now, I don't actually know that that's the way that it plays out on the ground, but one could imagine that ICE offices in Arizona might feel more emboldened to take advantage of the new enforcement context than ICE offices in New York and other immigrant-friendly jurisdictions. You've got 287G as a force magnifier, and I would expect, although I'm very interested to hear others, especially those of you that are coming from immigrant-unfriendly jurisdictions, one would expect that we'll have jurisdictions signing up again for 287G and having their local enforcement deputized to enforce immigration laws in a way that ramps up enforcement in those jurisdictions. And we may have other forms of validation from the executive branch and/or Congress for increased local enforcement action. It's possible that we could get federal legislation that validates something like SB 1070. And it's important to remember that Arizona versus the United States, the Supreme Court decision was contingent on a lack of express validation for SB 1070. If you had federal legislation that said SB 1070 is fine with us, then it's a completely different constitutional question. And it's not at all implausible that we could have that kind of validation from this Congress and this president. So David said that the Supreme Court is moving away from exclusivity doctrines, and this, I think, will only be accelerated by the new administration's policy. And although there are many contingencies here, there are probably more on the sanctuary zone side where we could have federal action that squeezes the sanctuary zones. Federal exclusivity is a dormant doctrine, so it's only about what state and localities can do in the absence of express congressional and executive branch policies. And obviously now we could have, at the same time that we might have validations of something like SB 1070, we could also have constraints imposed on more immigrant protective activity at the sub-federal level. And then we also have this wild card of state laws that squeeze sanctuary cities. In Pennsylvania, we have a law that's now working its way through the legislature, which would cut off funding for sanctuary cities. And this is obviously happening in many states where you've got this split between immigrant-friendly urban jurisdictions and much less friendly. Pennsylvania's Philadelphia and Pittsburgh and Alabama in between. So that's a dynamic that is also a wild card here. But it seems like there's still a very strong possibility of this increased variance in enforcement. And just to spend a couple of minutes wrapping up here, looking at what the consequences of this regional variation may be, and maybe some glimmer from an immigrant, from the perspective of immigrant interest, that this actually may end up being a less bad story than we might expect. And that works from the immigrant sorting and other economic consequences of increased immigration enforcement on a regional level. And here I think there's a very underappreciated aspect of earlier episodes implicating immigration federalism, and SB 1070 is really the leading case law. We have earlier ones, including Proposition 187 from the mid-1990s in California, and then also the twin the law that came in this more recent wave in Alabama, the HB 56 example. And so there are two things that happened in the wake of SB 1070 and HB 56, which were pretty clear. There was a pretty clear trajectory before the Supreme Court sort of cut off the conversation by gutting those laws. And one of them was that immigrants started leaving those states with immigrant unfriendly laws, or undocumented immigrants who left in non-trivial numbers. So in Alabama, which had a law that was more extreme than Arizona's, there were an estimated 40 to 80,000 undocumented immigrants who left the state and it's adopting that law. And then that's with respect to those who are already in place. If you're a rational immigrant to the United States and you're deciding where to go, obviously there are many factors in that decision, but all other things being equal, you're not going to want to go to a place where there's a clear culture, in this case the opposite culture, a protective one, a culture that's unfriendly to immigrants. And so you get this sorting, I think, so long as there are some jurisdictions that are visibly more friendly than others, immigrants will make a rational choice and go to those more friendly jurisdictions. There are other economic consequences, and most of you live in Arizona, and maybe you can educate me a little bit more since I was studying this from afar. There were other economic consequences to SB 1070 in terms of lost tourism and convention dollars. There's one estimate of 141 million of lost convention revenues in Phoenix alone as a result of SB 1070 and tourists who are deciding to go elsewhere. You had a travel advisory that was issued by the Mexican government to Mexican nationals not to watch out traveling to Arizona. And once an acting sub-federal jurisdiction is forced to shoulder the consequences, the economic consequences of its action, then it becomes a completely different policy balance. It's not just taking care of your anti-immigrant, your restrictionist constituencies, it's then you've got powerful constituencies on the other side. So I'm assuming that the hotel convention business in Arizona is a pretty powerful one. And I bet they were talking to members of the state legislature in, make this go away kind of terms. And then if the Supreme Court hadn't made it mostly go away, again, I'd be glad to be edified on this. It seems to me there's a good chance it would have gone away on its own, that it would have died a natural death. And the same thing, maybe I'm wrong, so it certainly, to the extent that those jurisdictions that act in immigrant unfriendly ways are forced to internalize the cost of their action. At least it makes it a closer case than if they're not jobs and tax revenues and other factors on the other side. In Alabama, the most dramatic economic upshot was as a result of the loss of undocumented immigrants leaving the state. Farmers had crops just rotting on the vine because there was nobody there to pay them. And that, again, a powerful constituency in a state like Alabama. Now there are major constituencies. We're living in a new world that for this model to work, in which these costs are internalized and in which there, at least on the margins, greater possibilities for states to walk back or to, one thing that was interesting in the context of the SB 1070 laws is that not as many states, there wasn't really a race to the bottom. You had a couple of other states, Alabama, South Carolina, Georgia, that adopted some variations on SB 1070, but it wasn't a large number of states, and you had many states where there was lip service paid to the restrictionist constituencies, but no real teeth to measures that were adopted. One mechanism was to draw out effective dates a couple of years. So it's like, okay, we're doing something about this. Legislators could say to their restrictionist constituencies at the same time that behind closed doors, they could tell their corporate donors, don't worry, we've got this under control. This is not actually going to create a fight in your interest. So I'll drop there. It's a kind of survival of the fittest approach to this, and it's one in which it's better to have the possibility for regional variance than setting the policy at the national level where you don't have these possibilities. And there's still some questions whether the Trump administration will allow for that regional variation, or whether it's just going to impose the worst on everyone. But there's at least this possibility in the modulation that's allowed, that's afforded by the possibilities of immigration federalism.
Thank you all. So why don't we take a few minutes and each of you respond to any comments from one another, and then
A couple of thoughts based on the presentations. I learned a lot, thank you. So Peter, I think you're right in that we could look at the different consequences of these anti-immigrant or unfriendly laws or ordinances. We can look to California, for example, and see and test it. So California in the 1990s passed Proposition 187, and now California is at the brink of passing SB 54, the state sanctuary bill. Not only that, California is also poised to pass a law that would provide a lawyer for all immigrants, most immigrants, in removal hearings, right? It excludes those with criminal convictions or criminal history. But in a place like California, it took 2 decades to turn from very anti-immigrant to something that it is today. So I could see, it would be interesting to see how that theory would work. Maybe they didn't leave, but something happened on the ground that shifted the political will of the people. Ming, I thought, I learned a lot from your talk as well, and it made me think about how private organizations, in fact, can be more incentivized to provide refugee resettlement policies or activities, the way that Canada and other European countries have done. So in other countries, there are private organizations that are able to sponsor refugees to come to to their countries. The United States used to have something similar to that started up, which began with President Reagan and ended with President Clinton. These private organizations on their own were given slots to sponsor their own refugees. And so under President Trump's administration, if there is we're seeing a reduction of the number of refugees coming here. Yes, you're right, states can play a prominent role, but maybe states can also further incentivize private individuals and organizations to participate more in refugee resettlement, and maybe push for extra visas that they will be in charge of providing financial, stability for those refugees and their families. And then, Jim, I wondered about tribal citizenship. I thought about what Peter said about state citizenship in New York, that bill. Have there been any movement among the tribes that you've seen of offering tribal citizenship for undocumented immigrants and their families?
That's interesting. No, we haven't. In fact, tribes are going through completely separately, kind of a crisis about who's a member of the tribe, and in fact, there's a painful episode going on around the country, mostly on the West, California and Washington, where tribes are disenrolling citizens in political factionalism expression, and maybe in an effort to control resources coming from gaming money. So you haven't seen that. In fact, there's really the opposite trend in Indian tribes.
I'll also just give a few quick reactions, which are more to pose questions rather than to provide answers. Rose, I thought your presentation about sanctuary campuses as a model for sanctuary next to cities and churches is a really interesting one. When you mentioned, the thing that really caught my attention is when you mentioned the possibility that higher education teachers and administrators might be considered de facto immigration officers. I thought that was a really interesting possibility to contemplate. And in particular, for those of us who study in this area, we know that Plyler versus Roe is sort of the foundation of a lot of what's happening politically and legally on campuses in order to protect dreamers or DACA beneficiaries. And so I think about that because Plyler, I think, laid some of the groundwork for a movement that I think is still emerging in universities. And I just wanted to highlight one area. We talked a little bit offline about this, but I do think that across the country we have, rightly, well-mobilized campuses for DACA students. And one thing that I've been starting to pay more attention to at my campus is the protections that we offer to the international students and scholars in light of things like the travel ban that I think have really highlighted the vulnerability of lawful temporary immigrants who are coming in on F1, J1, H1B visas. And of course, there could be even more of these types of visas that are affected should some of the other draft executive orders go into place. And so thinking about those people too as part of our campuses, what would it mean to provide a form of sanctuary? In particular, if we are talking about people who, I suppose, if the executive order is narrowed and we're only talking about entry, it's unclear how that will affect re-entries. But I know that, just to put out one practical and concrete example, I know at my university we've been having conversations about what happens to a PhD student who would ordinarily go home for the summer and that is confronted with the decision of either not going home, in which case will the university provide housing for that summer when they would ordinarily be living elsewhere, or if they do make the choice to go home. I mean, this is just a really tough choice, right? Do I finish my program or do I see my family again? But if they decide that they want to see their family, will we allow people to finish their programs abroad, as an example? So I wonder if there's space to join those movements and thinking about the university. My questions are getting longer than I meant. James, I was really struck by the way that you presented and reminded us of the long history of Indian tribes as sovereigns. And I think that is always an interesting way to frame the issues in immigration federalism. I mentioned that I tend to focus on cooperative federalism, one of the sort of the new federalisms. But going back to that idea of sovereignty, I think has real power and meaning in thinking about that relationship. And so I am curious to know, given that there is that deep grounding, is there still room for the kind of dynamic relationship that the cooperative federalism ideas that I'm thinking about can lead to? And then Peter, I have one slide, which is just that I wondered a little bit, when you talk about competitive federalism, I'm reminded of the idea of like, let's rely on the political safeguards, right, rather than the courts. And the starting premise for your remarks was that you posited a role of a limited judicial restraint that would allow for this sort of political flourishing. And I'm curious, as I think often is the case, because it's probably just what I happen to be writing about, but what about the role of the administrative? Because I think there is a disaggregation of the executive branch that's happening right now that is fascinating to watch unfold. You're seeing these daily political battles between the president, the White House offices, and the agencies, let alone the different layers of the agencies that we've been talking about throughout the day, everyone from street level bureaucrats and line officers to higher level policymakers. So I'm curious to know what kind of competition you see might happening there and to what result.
Well, first, let me respond to Ming's question. I think that, regardless of the strains in relationships, Mexico, U.S., the states, the tribes, etc., the Indian tribes have had a history, and the Optim in particular, of attempting to negotiate for their members to go back and forth. And have had some success, and in fact, a gate was built to allow the Optim to go back and forth. It's patrolled, it's guarded. Nonetheless, they made specific arrangements for their own members on both sides to be able to enter with tribal identification cards rather than necessarily passport. And so that has worked in the past. The question is whether it will continue to work in the future. I'm hopeful that it will. I'm hopeful of a few things in terms of reaction. Peter mentioned the word resistance, and talked somewhat about costs related to the executive order, the building of a wall, etc. And you have to wonder, we've all talked about practical reactions to what's going on. You have to wonder how much of this will actually occur based on the difficulty, the cost. If you on the wall, the talk of spending $10 billion on building a wall, and the thought of 15,000 ICE agents and 5,000 to 10,000 Border Patrol officers, the thought of on the Indian law concept, where the law is so complicated, difficult to understand for lawyers, law professors, and judges. How is a new Border Patrol agent or ICE agent going to go on a reservation, figure out what's Indian land, what's state land, what's federal land, what's trust land, who's an Indian, who's an immigrant, etc. Extremely difficult and likely to be dealt with practically and realistically.
So I'll be very brief, so we have good time for questions, but Ming's good question about safeguards here. I'm not saying the courts have no role with respect to immigration, just with respect to, on this particular question of whether sub-federal action is, to what extent it's preempted or not. And that's where I think that courts are less likely to interfere with restrictionists, sort of the force magnifiers at the local level than they will have been in the past, given the shift at the federal level. And whether, I wouldn't use the word, I'm not sure I'd use the word flourishing either with respect to the politics here in terms of how the administrative state may be disaggregated. And here I'm wondering where, I mean, again, it's back to Joe's talking about the different cultures from the bottom up, and I don't know enough about ICE culture to know what the potentialities are there for that part of the administrative state to act as a brake rather than the opposite, which is now they're going to feel like that the leash is off and they can enforce more up to the limits of the law. So on that score, I'm not sure how hopeful I am that sort of within sort of competition within the federal government that there's a lot of room for hope there. There's also, you don't have this substitutability where, if it's a choice between Arizona and immigrant and California, there's a lot of substitutability there, right? If you're a business, if you're a tourist, they're roughly similar quantities. If it's a choice between the United States and something else, it becomes more difficult to engage in that kind of competitive sort of vote with your wallet activity.
Great. Okay, let's open it up to questions.
Hi, my question, thanks for the all really interesting presentations. I have a probably fairly specific question for Rose. You brought up the previously obscure section 1373 that now is getting a lot of attention. And I am curious that you didn't have a slide, but the statutory language has a limiting clause that says notwithstanding any federal, state, or local law, and then it goes on to only apply to information sharing anyway. So it strikes me as, despite all the attention it's getting, highly limited in terms of sanctuary policy. One, because it actually has a narrow application anyway. But regardless of that, what do you make of that, the notwithstanding local and state law? It seems on its plain face that puts there to shield it from federalism objectives. So that also means that if a locality passes an ordinance, it can't possibly violate the
Yeah, I agree with you. No, I tried not to put too much text up there, so I'm limited to just those few things. But yeah, 1373 does include that clause, and then also, and I think in one point it says may, as opposed to may not prohibit, as opposed to shall not prohibit, right? And that is a response to the anti-commandeering principle, I think. So you're right, even though we hear a lot from politicians saying the sanctuary cities are in violation of federal law, when one looks at the statute itself, 1373, they're actually not violating federal law. But it takes a while for, I think, the general public to get there.
Just a quick, oh, sorry.
So this question, I think this goes to Ming, although, I mean, maybe it's more of a, maybe this is a rhetorical question, depending on whether you answer it or not. So I'm curious about your characterization of 5G, about it does talk about the state role in determining the placement and settlement in the jurisdictions. And so your example of Wyoming was an example of someone, a jurisdiction that really doesn't want to have settlement structure taking refugees. But then the Mike Pence situation in Indiana really wasn't about taking refugees. It was really about selecting refugees based on country. So I guess the question or the suggestion maybe is that if the federal government, through executive order or through legislation, empowers states to select refugees by nationality, will the federal government be able to delegate all of its power to a state to do so, both to determine what constitutes selection by nationality and when it's permissive? And I think it's an interesting question that we have that it sort of touches on what Peter raised about the ability to delegate power. So I just, because you touched on, I felt like, or maybe I missed it, but there's really two aspects of 5G. One is selection of refugees, period, and the other is the transferability of the ability to select by nationality.
I think briefly, in response to your question that's not exactly a question, I'll probably even answer that's not exactly an answer, which is, I think one of the distinctions is the one that you've made, which is that, as I understand it, Pence's order would allow us to talk both about that structural aspect, the withdrawal and the settlement, as well as the selection based on nationality, although the lawsuit, you're right, focused on the selection by nationality. But for that provision, I do think that it might be an example of the rights about the powers question. So we might throw that back.
I was really struck in looking at that opinion from the Seventh Circuit, how aggressive the three judges were, judges with a fairly conservative reputation, how aggressive they were in questioning what Mike Pence said about his justification. I once wondered if they would ever be as aggressive to a federal statute that empowered the states to do the same.
I had the same exact question. There's just a very quick follow-up to Mike and Rose's. I have the language here, and this is not, I'm not getting anything, actually, this is a very sincere question. There's notwithstanding any other provision of federal state law, the state government cannot do prevent the sharing of information. And maybe I just always read it wrong. I always kind of read that as like, it doesn't matter if the states say that we don't have to share information, you have to do it anyway. Right? Like you said, I'm not sure that the reading that Mike was given that allows states to just opt out is the only interpretation, and it gets me to the question that I was posing earlier about textualism and purposivism. Because when was this statute passed? Was it not passed in connection as a response to sanctuary cities? Am I wrong about that?
I have to look at so what was it, the New York versus United States litigation about New York sanctuary or non-cooperation policy? It's been a while since I read it, but I'm not sure. My reading of it is what my view is that this provision, and really it's not so much a notwithstanding, but for me it's the main part, that in my mind should draw the conclusion that states and localities may opt out because they can't be forced by the federal government to enforce immigration law.
So I guess I stand corrected. My understanding was that it was passed in response to sanctuary movements, and that if you do a textualist analysis, maybe that's the right way. But if you look at the context and the purpose of that provision, then maybe that's not the right interpretation. And that's why, again, the methodology of interpretation, broad and narrow, can have a very significant impact on this question of preemption.
Yeah, you could be right. I'm sorry. I'm just right now.
If I can follow up on that, I've been confused with law school by notwithstanding the process. I think on this one, there's, in addition to the federalism concern that I think might be a reason for beneficial to challenge why that's there are some other parts of the INA that be consistent with the reading that I have. For instance, on professional licensing, the INA allows the state legislature to explicitly allow a professional license. And so this would be sort of consistent with that. It would prohibit perhaps the sheriff from unilaterally directing his officers to not be able to do something, but would still allow a legislative body to operate.
I have a specific question for James and a thought for Peter and Joe. The question is, I'm wondering about when you have a tribe that straddles the border like this, I seem to remember that there's some question, and this is a vague memory of a tribe that I think is called the Kickapoo tribe that's in Texas that is a similar situation, and how U.S. citizenship status follows whether you happen to be born on the Mexican side or on the U.S. side. I seem to remember with the Kickapoo there was some statutory exemption that allowed them some special citizenship status or something. I'm wondering if that issue comes up here. I'm not even positive I'm correct about the Kickapoo, it's a vague memory. Is that?
Yeah, the Kickapoo in Texas, along with a Pueblo tribe in Texas, did get active in filing a complaint about the fence when it went up. And yeah, there are provisions like that in international law and that in Arizona as well that have allowed the tribal members on both sides to go back and forth. Not citizenship. Citizenship is definitely prescribed by.
Specific where you're born.
Yes. So the Otham on the Mexican side are Mexican citizens. The Otham on the U.S. side are U.S. citizens, but they do have rights to go back and forth. But if a hall is built, and without the possibility of going back and forth, they would have to travel hours to get to an international crossing, unless you create gates. And the creation of gates, of course, in a wall is something that would probably likely be resisted by the builder of a wall. So it exists today. There are gates. There's one gate that the Otham have used, San Miguel Gate, which just recently was closed because on the Mexican side, it was a private landowner, a rancher, who, for whatever reason, didn't want to get into the particular difficulties of dealing with the cartel and closed the gate. And so it's a continuing problem, even with the legal ability to go back and forth. There are practical problems with it.
But I was thinking, if you had the U.S. citizen diaspora community with special statutory or historical rights living on the Mexican side, there might be a due process theory that would be available in terms of needing better access to each other. Again, just thinking back to that.
I think you're right.
With Peter and Joe, I was wondering, in terms of institutional culture, it seems to be the likelihood of ICE being of anybody in ICE being a source of anything positive strikes me as not very high. But this is part of the consequence, I think, of separating the agency in 2003, because now we have a bifurcated agency in which, if you're only looking at ICE, you've already had that sorting function of people who are totally enforcement oriented, whereas before 2003, not that INS was so wonderful as we all remember, but you at least had different impulses within the same agency, and therefore a more fertile culture in some ways for cross-pollination.
If I can intervene, I know, Dan, you directed that at Joe and Peter, but if I can interrupt on the same point. So I recently finished an article that's coming out in the Administrative Law Review called The Administrator in Chief, and of course it feels very out of date because it's about Obama's enforcement policies. But one of the things I was very interested in was this issue of agency culture. And I did interview some high-level policy officials in ICE, USCIS primarily. It was harder to get access to CBP. But one of the things that I found to be really interesting, when we've been talking about discretion throughout the day, is that I do think one thing that feels very different about the kind of discretion that maybe, to use the metaphor that's been invoked a few times, the unshackling of ICE or the unshackling of CBP, is that it seems to be a somewhat arbitrary exercise of discretion, as opposed to the kind of prioritized enforcement, a more disciplined form of discretion that came from high levels to, in part, control the exercise of discretion by lower level agents within the federal bureaucracy. Right, and so I'm not defending ICE, but I will say that that is one story that I got in talking with high-level officers as opposed to street-level officers in ICE, is that the imposition of certain priorities from the top did in some ways counteract the rogue officer, right, in a way that I'm not sure we see suggested by the substitution or maybe just the eradication of a priority system in the current regime.
One final question.
So this for me, two-part question. The first part is, what concerns does 5G raise for you, if any, about administration, domestically, administration of the security program? Other concerns because states that want to opt in, and states that don't want to opt in. And obviously, the president, she's trying to empower states to get more involved in what that look like, I guess. And then the second question is just about the state's own incentives. Do you know if there are studies about the impact of refugee resettlement on state economies?
Those are both good questions. I mean, the second one, just very quickly, I don't know, but I would really like to look into that. And I was really recently appointed to the Colorado's Advisory Council to the U.S. Commission on Civil Rights, and so I was going to propose something like this as our project for the year. So maybe I can get back to you and find out a little bit more. On the first question, yes, I am very worried. I tried to lay it out sort of as a typology, showing that there are all these possibilities. But if you're just asking for my normative priors, I do think it's worrisome. Both in the specific case study and in general, that you might have the possibility of states being able to, again, even without a veto power, right, being able to so encumber the federal policy that essentially the policy is hobbled. And I think in particular in this case, because there might be reasons for that form of policymaking in other areas, but in particular in this case where there also are countervailing international humanitarian norms, I do think that is potentially very troubling, that you could cripple a program and sort of constructively veto it, even if you may not formally veto it.
Great, well, let's all thank our panelists.